You're driving home when the blue lights appear in your rearview mirror, and the moment you roll down your window, the officer says those 4 words that can change your life. I can smell cannabis. Most people think this phrase is a legal skeleton key that gives the police an automatic right to tear through your car, but the reality is far more complex and high stakes than you've been led to believe. In fact, what an officer claims to smell might not just be the start of a search. It could be the start of a misconduct tribunal that ends their career. You might feel like you have no choice but to sit back while they look through your glove box and boot. But the law in England, Wales, and Scotland is designed to prevent these encounters from becoming arbitrary fishing expeditions. If the grounds they provide don't hold up under the cold light of a courtroom, the consequences for the police can be just as severe as they are for you. The single biggest myth on UK roads is that the police can search your vehicle based on a hunch or a feeling that something isn't right. Under Section 23 of the Misuse of Drugs Act, 1971, the law actually requires reasonable grounds for suspicion, which is a strict legal test, not an invitation for guesswork. This means an officer must have objective facts, intelligence, or observations that a reasonable person would agree point toward the presence of drugs. A hunch or an instinct that cannot be explained to an objective observer can never, under any circumstances, amount to reasonable grounds for a search. While the smell of cannabis can be one of those objective factors, it is not a magic word that bypasses your rights, and it cannot be used as a cover for discrimination. Furthermore, the law is very clear that an officer cannot search you simply because of your age, your race, your nationality, or what you happen to be wearing. Even your criminal record alone is not enough to justify a search under Section 23. In Scotland, the rules are even tighter. An officer cannot even search you with your consent unless they have a specific statutory power to do so. If you think the police can just say they smell something to get around the law, look at the 2022 tribunal that rocked the Metropolitan Police. 2 officers were fired for gross misconduct after they lied about smelling cannabis to justify searching athletes Bianca Williams and Ricardo dos Santos. The panel found there were absolutely no objective grounds for that suspicion, proving that the legal bar for a Section 23 search is real and enforceable. This wasn't just about an apology, it was about the fact that smelling cannabis is a specific claim that must be backed by reality. Another high-stakes example involves Manny Arthur, the founder of the Black Cyclists Network, who was stopped while waiting at a red light on his bike. Police claimed they smelled cannabis, but the Independent Office for Police Conduct later upheld his complaint, finding that the grounds for the search were simply not reasonable. In Northern Ireland, the pressure on these powers is even higher, as a staggering 73% of all stop and searches are conducted under the Misuse of Drugs Act. With nearly 20,000 people stopped in a single year in that region alone, the room for error is incredibly small. Here is the insider detail most people miss. If a search is conducted without those objective grounds, any drugs or evidence they actually find might become completely useless in court. Under Section 78 of the Police and Criminal Evidence Act, or PACE, a judge has the power to exclude evidence if the way it was obtained would make the trial unfair. This means a successful search where drugs are found can still result in the case being dropped if the officer didn't follow the rules. This is why the GOWISELY procedure is your best friend during a stop. Before the search even begins, the officer is legally required to give you their name or identification number, their station, the legal power they are using, like Section 23, and the specific grounds for their suspicion. You are also entitled to a search record at the time, and it is actually unlawful for an officer to refuse to give you one just because they say it will take too long. If the search is going to be thorough, like asking you to take off a t-shirt, it must be done out of public view, perhaps in a police van. However, if it involves the exposure of intimate body parts, it cannot be done in a van. It must be done at a police station or a nearby private location. In these cases, the officer searching you must be the same sex as you. Plus, you should know that police body-worn video is typically only kept for 30 days. If you believe the smell was fabricated, you have a very narrow 1-month window to ensure that footage is preserved as evidence. This legal framework is designed to protect both the public and the officers on the front line, but it only works if everyone knows the rules. For the driver, the warning is clear. You do not have to give your name or address unless the officer points out a specific offense they suspect you have committed, but refusing to cooperate with a lawful search can lead to an arrest for obstruction. Never physically resist a search, even if you are certain it is unlawful, because reasonable force can be used to detain you once the power is invoked. Even bicycles aren't immune. Cyclists can be stopped at any time without a reason and then searched if that smell or suspicion is established. For the police, the warning is equally sharp. Misuse of these powers is explicitly defined as harmful to policing and leads directly to community mistrust. Senior officers are required to monitor records for patterns of disproportionality, and supervisors must take action if they find officers are searching based on personal prejudice. In fact, if your car is on private property, like a driveway, the police might actually need a warrant just to enter the property before they can even use Section 23. Does the power to search based on a smell strike the right balance between keeping our streets safe and respecting our private lives? The primary purpose of stop and search is to enable officers to allay or confirm suspicions about individuals without having to make an arrest. But that power is not a blank check. It is a massive intrusion on your liberty that must be brief and conducted with courtesy and respect. The key takeaway is simple. Know your GOWISELY rights, stay calm, and always ask for the objective facts that justify the intrusion. If you've been through a search and feel that reasonable suspicion was just a cover for a hunch, remember that you have the right to challenge it through a formal complaint or legal action. This video is for informational purposes only and does not constitute legal advice. If you have been affected by these issues, you should speak to a qualified solicitor or your local Citizens Advice Bureau to protect your interests.